Yes.
It's Jason Beer, representing the Secretary of State for Communities and Local Government. I had indicated to Mr. Millett that I didn't intend to say anything, and indeed I don't intend to speak to the two-page document that we submitted, given conversations that I'd have with him and the submissions that he'd made yesterday. It's not necessary to do so. Can I just briefly, therefore, address you and try and assist you on the two supplemental issues that have arisen?
Yes, of course.
And that you've been putting to other advocates. Firstly, then, a consultative panel. If such a panel encourages the opening of lines of communication and a dialogue between former residents, the relatives of the bereaved, and survivors of the disaster, and if it allows dialogue outside of the formality of hearings such as this, it has much to be said for it, in our view.
Thank you.
As for position statements, we do not object in principle to the service of position statements. But when you're considering the request that's been made to you, we would respectfully ask that you bear in mind the following 3 points. Mm-hmm. Firstly, of course, these are inquisitorial proceedings, with you as the Inquisitor-in-Chief. Mm-hmm. Pleadings, of which position statements are a species, are not a feature of such proceedings for good reason. And that may be why they've not hitherto featured in any of the approaching 24 inquiries established under the 2005 Act, in which the 2006 rules apply to.
But could they not be helpful in clarifying the ground for the benefit of all core participants and others?
Of course they can, and it will be within your Section 17 power to require them. And I'm going to suggest the potential solution in a moment, and this is the run-up to the wicket, effectively.
Right.
Second, an element of realism needs to be brought to bear to the exercise, because the application is made on the basis that the statements will help to narrow the issues and therefore save time and cost as one reason for them. But this inquiry is very much multi-party. And there are no parties, of course, but in litigation equivalent, it's supercharged multi-party litigation. And there, of course, where what CP number A says about an issue is not going to bind CPB. And so the likelihood of being able to take things completely off the table is perhaps more illusory than real. The third point, as others have said already, is that if position statements are to have value and meaning, they must come after disclosure and expert evidence. Indeed, that was one of the reasons why Sir John Goldring, in his ruling, you may look at it at your leisure, it's paragraph 25 of his ruling, refused the equivalent application that Mr. Weatherby made in the Hillsborough inquests. Of course, that was slightly different. The application was made whilst the inquests were on foot, so we were part way through them. But what he said was, I couldn't have ordered them before we started at one of the pre-inquest hearings because there hadn't been disclosure or expert evidence at that stage. And so a potential solution, in particular where you're operating necessarily under a compressed timescale, and therefore there isn't going to be the luxury of building in additional time to allow people to pause for thought, consider all of the disclosure they've got, and file a position statement, is to give directions as to the content of Rule 10 opening statements. Normally parties, core participants, are allowed almost a free rein as to what they may say. But you could, under your Section 17 powers, give directions as to the contents of them and make that the occasion on which parties must, in relation to a series of identified issues, set out their position with clarity. And that's the solution that we would respectfully propose. So that's all I intended to say.
Yes, well, that's helpful. Thank you very much indeed. Now that you've been very economical in your use of time, I must say, all of you. That completes the list of those who I have who are expecting to speak on behalf of core participants. Can I just check there's no one here who thinks he's been overlooked or she's been overlooked because there's something you needed to say? No, right. Thank you very much. Well, in that case, I'll invite Mr. Millett to respond to the